Good afternoon, everyone. Today's session is a continuation of our IPC BNS PYQ series, and today we take up general exceptions. Now, what I want to aim for this particular session is that we complete the most predictable questions that come from general exceptions. So, the PYQs, which are most often that I have seen that are asked, are in relation to the Latin maxims or the principles that are attached to the general exceptions. So this session we just look into those maxims which are a part or which are the basis for general exceptions, and then look at some of the questions, the type of questions that are asked in relation to them, and then maybe in our next sessions we can look into situationals in relation to general exceptions. So, as I mentioned, that one of the most predictable questions that has been asked in any state in relation to in relation to general exceptions are the Latin maxims, on the basis of which, or the principles of these Latin maxims have often been the yardstick on which these exceptions have been created. So the first one that I'm taking up is in relation to incapacity, which has been dealt with under our exceptions with regards to age in relation to children below 7 years of age under section 20 of BNS or 82 of IPC, where if a child is below the age of 7 years, then they cannot be made liable to a crime, they cannot be punished for that crime. On the other hand, if the child is above 7 years of age and under 12 years of age, then in that situation, if the child does not have an understanding of the nature and consequences of his conduct, then he or she may be protected from liability. That has to be proven. So here there is a conditional aspect, there is no absolute immunity. But in the first one, where the child is below 7 years of age, there is absolute protection given to such children, the children of ages below 7 years. Now, this is based on the maxim of doli incapax, which means incapable of doing any harm. This maxim has been asked very often in your paper. One question or one sample question that I have provided to you is that section 82 and 83 of IPC embody which legal principle? And here you see that they have mentioned a cluster of Latin maxims, out of which you must choose the correct one, which is doli incapax. Often the question will include the principle or the Latin maxim like doli incapax in this case, and you must be well versed with the section attached of the exception that it is in relation to. So be careful to remember the section and the provision, the meaning of the Latin maxim, because either ways or they can be interchanged and asked to you, not necessarily the section or not necessarily the principle is asked to you, they can be alternatively asked to one another. So when in relation to age, there is exception provided under IPC and BNS under the following sections. The maxim involved is doli incapax. Another common question that comes in is in relation to the exception provided to us where it is out of necessity that you cause a particular harm. It states that nothing is an offense by reason of its being done with the knowledge that it is likely to cause harm if it be done without any criminal intention. So you do have knowledge, but you don't intend to cause the harm. You do the act in good faith for the purpose of preventing another harm, whether to person or property. So you do cause harm to another person or property, but you don't intend it. You may know about it, but it is an act in good faith to avoid other harm. So this is considered a situation where you don't have an option. It's a necessity, right? And this is based on the Latin maxim jus necessitas, which means necessity knows no law. Where there is no option and you have to do something, then you may get some protection under the law. So that is the principle on which section 19 of BNS or 81 of IPC has been made, and again is a question that has been often asked, right? So they have asked that where is the Latin maxim under general exceptions of IPC or BNS applied, and we know that the answer is 81. Again, a question which can come interchangeably. They may ask you the section, or they may ask you the maxim which is related to section 81. Another common question which is in relation to an exception and to which is attached a Latin maxim is the insanity plea, which says that nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. So basically, the person is in such a mental state that they do not understand the nature of their act, or that what they are doing is wrong or contrary to law. This is based on the Latin maxim non compos mentis, which means a person is not in their right mind to judge right from wrong. They don't have the mental capacity to make decisions or to decipher whether the decision is right or wrong. So, non compos mentis is the basis for our plea of unsound mind or a plea of insanity, which is available under 84 of IPC or section 22 of BNS. Now look at the question asked. Non compos mentis denotes every person is presumed to be sane until proven to the contrary? No. When a criminal act is performed in derangement? No. When the cognitive facilities are such that he does not know what he has done. Fourth option given to you is not serene memory from birth. Our answer is answer C. So different ways in which Latin maxims have been asked to you. I've tried to provide those type of questions which give you a range how the maxims can be asked to you. The next one is in context of the fact that if you consent to a certain action, then it can reduce your liability. This section states that nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has consented, whether express or impliedly, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to the risk of that act. It simply means that where a person is above 18 years of age and has consented to something, and the person who is taking the consent has never intended to cause death or grievous hurt, or he did not even know that it is a likely outcome, then in such situation, if harm is caused where the consent is present, or such harm is caused which is known to be likely to take place in such a case, or in doing such an action, then in that situation you cannot make the person causing harm liable, because you agreed to it, you volunteered to it, you consented to that action. And this is based on the famous Latin maxim of voluntas non fit injuria, which simply means that if you volunteer to something, it cannot you cannot make a person liable for that later. In that situation, no harm is done. A direct question has been asked where the maxim is quoted, and you are expected to highlight the correct section, which is section 87. This is the most common question in relation to Latin maxims that is asked. This particular provision deals with the principle that where the act is too minor or too trivial, then in that situation the court will not engage in it because of the triviality of the incident that has taken place. In our in our legislation under BNS and IPC, it is mentioned as nothing is an offense by reason that it causes, or that it is intended to cause, or that it is known to be likely to cause any harm, if it is so slight that no person in ordinary sense and temper would complain about such a thing. So the thing is so minor, वो इतनी छोटी सी चीज है कि आप उसके बारे में कंप्लेन करना लॉजिकल कोई भी इंसान नहीं समझेगा. Right. So this is based on the Latin maxim of de minimi non cura lex, which means the law does not concern itself with trifles. It does not engage with something which is very minor in nature. Very important Latin maxim. Most often, if a maxim has to be asked, this is the one that I have seen that comes in the papers. So, de minimi non cura lex has been asked in this one manner, multiple ways in which it has been asked. This one says that it tries to find out the meaning of the maxim and says nothing is an offense which is done by a child below the age of 7 years. Trifling acts do not constitute an offense. This is our answer. Every person is liable for his own acts. Wrong. Necessity knows no law. So you can see that they have also tried to mention the meanings of other maxims, and if you are not clear about these meanings, you may get confused. So be cautious to learn the meanings of individual maxims related to those exceptions. Lastly, there are some other maxims also in relation to these exceptions that have come in papers. For example, once I have seen that in relation to unsound mind, a Latin maxim known as furiosia nulla voluntas est has also been asked, which means that no culpability can be fastened upon an insane person as they have no free will. Now, this is not usually referred to us by us or in Indian laws, but we see that while explaining the insanity plea, it is often referred to as a principle. So, it is wiser to be aware of this Latin maxim also. Secondly, when we discuss mistake of fact and mistake of law, there are general exceptions which deal with it. If you remember, it is in context of where somebody feels that they are justified in committing a certain action, and even if it is under a mistake of fact, then they are protected under the law. And similarly, where a person who is bound believes himself to be bound by law under a mistake of fact, they may also be protected under the law. Because it is a mistake of fact, there is no protection in case of mistake of law. And these two are based on the premises of ignorantia facti excusa and ignorantia juris non excusa, which means that in case where you have a mistake of fact, it can be an excuse, and ignorance of fact can be an excuse. Alternatively, a mistake of law or ignorance of law is not an excuse. Again, maxims which are often asked to you in your papers. I hope students this short video helps you understand the basic and direct questions that come in your paper in relation to general exceptions. In the next class, I will take up situationals which come in relation to general exceptions. If you have not seen the BNS PYQ series, you can start watching it now. They are short videos which I hope to address small concepts quickly and also deal with questions related to them at the same time. Thank you so much. I'm going to shortly start a Juvenile Justice Act series also with relation to PYQs. I hope you will join me in those lectures also. Thank you so much, students. Have a great day ahead.